Hello, friends. Today we are going to discuss about the eviction of tenant as per East Punjab Urban Rent Restriction Act 1949, which is applicable in Haryana. What are the rights of the landlord and what are the rights of tenant? So, in this particular case, we are going to discuss a special leave petition which has arose of civil appeal. Um, which was allowed by the High Court against the order of the appellate authority of rent controller. And I'm going to give you the facts of the case. The facts of the case is this: the landlord has given the property to the tenant, and after getting the property on rent by tenant, tenant has sublet that property to somebody else. So thereafter, landlord had filed an eviction petition in the rent controller, and he has stated that first of all, the property which was given to the actual owner, it was given to somebody else without the permission of the landlord. He was not agreeing to it, and moreover, uh, the the secondary tenant was not paying the rent on the time. Thereafter, he had filed a rent petition. In the rent petition, rent controller has framed two issues. One issue was that whether the tenant is paying the rent on time or not, or whether the property is required by the landlord for its own purpose or not. So, in his pleading, landlord has stated that he wants the property for his own son, who has completed the CA, and secondly, there was no consent obtained by the subtenant to get the property on rent. Thereafter, rent controller has stated that since the property which was given on rent to the tenant and he had further given to subtenant, he was paying the rent on time, but since the property is not required as per the rent controller for its own purpose, no eviction was passed. So thereafter, aggrieved by that judgment, he had gone to the appellate authority, and appellate authority has reversed the finding, saying that usage of the property cannot be construed by the expression of the tenant. If landlord is saying that he needs the property for its own use, it has to be transpired in the same sense only. It cannot be interpreted otherwise. Thereafter, dissatisfied with that judgment, the tenant had gone to High Court, and High Court has reversed that finding, against which the landlord, being appellant, has preferred an appeal in the Supreme Court. And Supreme Court, after discussing the entire case, has given the finding in favor of the landlord that he has the right to get the property as per the pleadings.